All right, good afternoon. Welcome to oral argument session here at the 5th District Court of Appeal. I'm Judge John Harris, joined on the panel today by Judge Eric Eisnagel and Judge John McIver. We've got one case left on today's docket. It is case 22-2522, Ricky Allen Hestikin and Ring Power versus Keith Michael Hughes. If you have any your cell phone or other noise-making device, please go ahead and silence it or turn it off at this point so that we're not interrupted. And just to remind you all, the proceedings are obviously being recorded today, as well as being live streamed on YouTube. 20 minutes for each side. Appellant, you can reserve as much of that for rebuttal as you would like. The default is 5 minutes, but we can change that if you would like something other than that. And
Your Honor, I was going to say 5 minutes is fine for rebuttal. Thank you, sir.
Very good. Then if you're ready, sir, you may proceed.
Thank you, Your Honor. May it please the court. Michael Korn of Korn and Zemer, Jacksonville, on behalf of the appellants Hestikin and Ring Power. I first want to just personally thank the court and Mr. Curry for your courtesies in allowing the oral argument to be rescheduled in light of my conflict with the first DCA earlier this week, and I appreciate that. The case involves a jury verdict after a multi-day trial. Central issues to the case were whether the plaintiff, Mr. Hughes, was intoxicated and the level of intoxication at the time of the collision, and issues pertaining to the speed of his vehicle and the configuration of how the Hestikin truck was turning onto the highway when Mr. Hughes collided with him. In order to move that issue forward, both sides presented expert witnesses. Prior to trial, the defendants filed timely and detailed Daubert motions challenging two of the plaintiff's experts, which are of issue on this appeal. First, the toxicologist, Dr. Rose, and next, the accident reconstructionist, Mr. Murdoch. Where there are two issues involved in this appeal that relate to the Daubert matter. First, we submit that the court did not adequately fulfill its gatekeeper capacity by finding that either of those experts met the Daubert criteria. We explained in some detail in our brief, especially as to Mr. Murdoch, the fact that he did not rely on sufficient facts, his methodology was flawed, and the methodology was not accurately and reliably applied to those facts.
As far as the lack of findings, where is that preserved?
Well, Your Honor, it was we preserved our objections to Daubert during trial at several times, and I can give you the citations to that.
Yeah, no, I was more specifically the lack of findings, given the trial court an opportunity to realize that it needed to make, or at least arguably needed to make specific findings, that the findings that it made were not sufficient. You know, that specific issue. Yeah,
well, and to be clear, there were, in essence, no findings. The court announced at a pre-trial.
Okay, fair enough that there were no findings. When was the court trial court put on notice that it was in error for not rendering findings?
There is, I cannot point, Your Honor, to a specific phrase or line in the transcript where somebody says, gee, Your Honor, you have to make sufficient findings. But that's really a function of the court's own role as the gatekeeper. Secondly, we would suggest that the agency here is not just solely on the Daubert movement. In other words, there was no objection made by the plaintiff about the sufficiency of the findings. They take their chances just as well.
But they're not challenging the findings on appeal, are they?
Well, they're not challenging the ability of their experts to testify.
They're not challenging the lack of findings, are they, on appeal?
Well, there's no cross appeal, so Your Honor, right. The answer would be correct.
So they may not have preserved the issue either, but for them, it maybe doesn't matter because they're not raising it on appeal.
Well, Your Honor, I would respectfully submit that if nothing else, it is fundamental error for a court to give no findings to allow this court to provide meaningful appellate review to the gatekeeper analysis that the court is supposed to do in the first place. And even if it's considered a harmless error with respect to the preservation, we submit that the plaintiffs cannot meet the Special versus West Boca standard for determining whether this was in fact harmful or harmless error. So the fact that the trial court played it somewhat loose with respect to just announcing at the August 10 hearing, I'm going to let Dr. Rose and I'm going to let Mr. Murdoch testify. He did qualify a little bit of Murdoch's testimony. He said, I won't let him go into human factors issues and I won't let him give legal opinions. That was the sum and substance of the findings, if you will. So, Your Honor, I would submit that it was preserved in part by the continued preservation of Daubert objections during trial.
So going to, I think it was Murdoch, you're the expert on speed of the vehicle. Is that correct, Murdoch?
Yes, sir.
And I'm somewhat sympathetic to the record because it appears that that your side attempted to raise this several times, but it looks like each time the trial court sort of said, "Hey, let's wait, let's take that up closer to trial," sort of thing. It didn't seem like the trial court gave a definitive sort of ruling on it each time, saying, "Hey, let's go ahead and make your objection when it comes up, and we'll deal with it closer to trial." And then the problem, and look, I understand that creates some difficulty for counsel below. There's no doubt. But then later on Murdoch, when the speed issue finally came up, counsel said something to the effect of, "Well, Your Honor, I need to talk to my co-counsel on this. I can't get a hold of him or her. Let's table the issue." And then I can't find where it was actually specifically raised after that.
Well, Your Honor, that I think was, and this was a colloquy that occurred in the middle of trial. Day 2, I think, was what Your Honor was specifically referring to. And the trial judge says, well, let's deal with it because Murdoch's not testifying today.
Right.
So the following day, day 3 of trial at T 436 and 437, the defendants again renew their Daubert objections to Murdoch.
Yeah, but
I don't know how much more the defendants were supposed to do at this point.
I mean, do you agree that it was a very generic, "Hey, we renew our objections," as opposed to taking up the specific objections to Murdoch and the speed opinions?
Well, but part of the problem is the speed opinion, of course, is a moving target here. Pardon the pun. Mr. Murdoch, when he was deposed, was opining somewhere between 52 and 60 miles an hour was the speed that the Hughes vehicle was traveling at the point of impact. He even said, and so the analysis of whether the Daubert challenge should have been sustained needs to be considered in the context of what did the court hear on August 10, when the opinions that were going to be relied on by the plaintiff were being put out. And what's interesting about that, of course, Your Honor, and we talk about this in some length.
Counsel, I'm not entirely sure that's right, given that the trial court said, I'm not sure that the trial court was obligated to rule that moment, right? Well, why can't the trial court, at least in certain circumstances, use discretion to say, "Hey, I'm not going to rule on this right now, bring it up again when it comes up at trial"?
Well, with all respect, Your Honor, I'll refer you to page 9709 and 9710 of the record. This was the transcript of the pretrial hearing on August 10, which the court described as his orders hearing, because there were a large number of motions in limine and other matters that were before the court. Trial is coming up the following week. And the judge specifically says, after he deals with one of the other motions in limine, he says, let's move on to the defendant's motion to preclude the testimony of plaintiff's expert John Murdoch and incorporated memorandum of law. That motion is also going to be denied. And then the discussions that come afterwards are after this court has already made the decision. So the fact that there were discussions about specific elements does not mean that the court adequately fulfilled the Daubert requirements. And the other thing that I would just remind the court is that here, the fact that Mr. Murdoch wasn't going to testify until later on in the trial doesn't mean that the court hadn't already made a definitive ruling. That ruling.
Counsel, again, I'm sympathetic to your side did raise this numerous times, and each time the trial judge seemed to say, hey, well, I'm not going to rule on it yet. Let's deal with it later. Right. I understand that creates difficulty and makes the trial counsel's job a lot harder. I get it. But nevertheless, if the issue had been definitively ruled on, why did counsel say, oh, well, Your Honor, let's table the issue for now. I can't get a hold of my opposing counsel. There must have been something that the trial judge was interested in hearing, and there must have been something that the counsels below had to say to the trial judge that never got said. As best I can.
Yeah, I'm sorry. What's also significant to that is the fact that the court also, when he made a definitive ruling, and that's the ruling that I just referred to at 9710. But he also says that I've made some notes, and I'm quoting now from the court's statement. I've made some notes about some specific things as far as what was testified to in the motions, and that Murdoch cannot testify to and would be precluded from testifying to, such as human factors, elements, legal conclusions, those kind of things I think that are in there being his deposition testimony. So I think that's the context of how the court ought to view what Your Honor described as the keeping open matter.
What did the trial judge say right after that part you read to me?
Well, he said, and that's also significant. He says, then prepare a detailed motion in limine, because I've made several notes. Even though I'm saying he can testify, he cannot testify to everything I read. That's the human factors, the legal conclusions. So the defendants did just that. They filed a motion in limine, both as to Rose and as to Murdoch. And there was no formal written ruling ever made. The court basically denied it by allowing both of those experts to testify during trial.
Well, so, I guess when counsel said, let's table it for now, Your Honor, what was that about then? If that wasn't about,
I'm sorry, Your Honor, go ahead.
The way I read the record, it sounded like that was very much about Murdoch and the speed opinion.
It was one factor that the two defense lawyers wanted to be sure of before they stated something. But that was, again, Your Honor, at day 2. This is before Murdoch testifies, and before there is yet on day 3, when Murdoch actually does take the stand, where the issue arises. And I think that to put the defense to the burden that the plaintiff would like them to do is unrealistic. I don't know how much more the defense could have either preserved or pointed out to the court. Either you're going off the wrong track because you haven't given us sufficient findings, whether orally or in writing, and you haven't considered the multi-step analysis that Daubert requires. It's just not there. I would submit also that this was significant because everybody was kind of in the know, if you look at the verdict form, that it was important for the plaintiff to ensure that if any negligence was attached to him, that it didn't exceed 50%, because he would fall under the statutory prohibition in 768.36. So both Murdoch as to speed and Rose as to intoxication were done purposefully to inhibit the jury's consideration of Mr. Hughes's negligence. Now, I know, and we acknowledged in the briefs, the jurors gave 30% of the negligence to Hughes, 70% to
Hesketh. As to expert Rose, if there was error there, how is it not harmless given the verdict where the jury expressly find that the plaintiff was over the legal limit?
It did, and that was the point I was trying to address just a moment ago, which is that Rose's testimony was, and we know Rose, he's the DUI guy. He's the guy who tries to go around the country lecturing to DUI lawyers on how to get out of blood tests. The goal was to minimize or question how intoxicated this fellow was. And his entire opinion was based on what? The self-serving and obviously incomplete memory of Mr. Hughes, who said, all I can remember of the night at the casino was I had 2 drinks, maybe one mixed drink, maybe 1 beer. So it's not harmless error. And I would respectfully submit that even if it was harmless error,
well, how is it not harmless when the jury expressly found that he was over the legal limit. Walk me through that.
Because the goal was to ensure it was a two-step process. The plaintiff's goal at trial was to ensure that they didn't rub up against the 51% statutory bar that I mentioned. And that's where Rose comes in. That's our position. I'm almost into my rebuttal time, but if I might, Your Honor, I just want to mention we did raise two other issues. One of them was the collective problems that resulted either from trial counsel's comments, his attacks on the defense experts that were uncalled for, in essence, using the orders in limine as a shield against Mr. Hughes, but as a sword against the defendants, especially with respect to his military service, and the VA records, which showed his intoxication history, and finally his comment about why would you not have driven drunk? Well, that was because a family member caused a drunk driving homicide. That was the subject of a order in limine that the plaintiffs wanted, but the plaintiffs come right out of the box on Mr. Hughes's direct examination. That's the first thing. Why would you not have been driving drunk? And he goes into it. That's error. I'll reserve the balance of my time. Thank you.
All right. Thank you, Mr. Corn. 4 minutes, 32 seconds remaining. Mr. Curry, if you're ready, sir, you may proceed.
Thank you, Your Honor. Good morning. May it please the court. Lance Curry on behalf of the appellee, Keith Hughes. We ask this court to affirm because the appellants haven't demonstrated any error, much less an abuse of discretion, and the vast majority of the issues that they've raised were not preserved for review. I'll start with the Murdoch speed opinion that Judge Eisenhower, you were asking about. When the court made that Daubert ruling, as I think counsel read, the court specifically said that Mr. Murdoch can't testify to everything, and instructed the appellant's counsel to have a detailed motion in limine that we'll walk through in more detail. And counsel said, yes, Your Honor, thank you. And they did that. They filed a detailed motion in limine and brought it up to the court. And the court, in response to that motion in limine, didn't say, hey, I've already definitively ruled on this. This is an easy one, move on. The court began asking questions about the challenge to Mr. Murdoch's speed opinion. And then in response to one of those questions, appellant's counsel said, can we table this issue while I contact counsel? And the court said, court goes on to address some of the issues dealing with Mr. Murdoch, and then says, quote, we'll address the other issue with regards to speed later. We can table that. So he did exactly what appellant's counsel asked him to do. And then they did not bring it up again. They did not ask the court to rule on the issue. They made a general objection before trial regarding Daubert in general. But when Mr. Murdoch testified at trial and offered his opinions, there was no contemporaneous objection. As the court well knows, if there's no definitive ruling, which there wasn't here, yet counsel has to contemporaneously object to the testimony. That wasn't done here. Therefore, the issue is not preserved. But even if it had been preserved, there was no abuse of discretion in allowing Mr. Murdoch to testify here. I think it's important to think about what does it mean to be an abuse of discretion in this context. The federal courts talk about it being the decision must be manifestly erroneous. And in Florida, we talk about it more in the context of no reasonable person would adopt the trial court's view. And I don't know how it could be said that the trial court abused discretion in allowing Mr. Murdoch to testify about the speed opinion when he essentially did almost exactly what the appellant's expert did in this case, just reached a different conclusion. In essence, at the end of the day, appellant's expert, Mr. Paradiso, he relied on tests involving a full frontal impact into a rigid barrier, and Mr. Murdoch, in contrast, relied on narrow object collisions. That's really the big difference in their opinions in this case. They take issue with his reliance on Mr. Murdoch's reliance on photographs and looking at photographs. Mr. Paradiso did exactly the same thing. In fact, in his deposition, Mr. Paradiso said, this is on page 3476 of the record, he said, to be honest with you, I did not fully quantify the amount of damages to Mr. Hughes' vehicle. I merely compared it to damage and a similar impact involving a similar vehicle to Mr. Hughes. Mr. Paradiso testified at trial that he used essentially the same general method that Mr. Murdoch used at trial. So I think it's really difficult for the appellants to suggest that Mr. Murdoch's opinion in this case is not based on sufficient data, not reliable, when their own expert did essentially the same thing and testified to that. Moving to Dr. Rose's opinion, I think it's important to understand that unlike Mr. Murdoch, they only challenged the issue of whether Dr. Rose had sufficient facts and data for his blood alcohol content opinions. There was some talk in the briefing about Dr. Rose's criticism of the alcohol serum test. They did not move in Daubert to exclude those opinions. So in fact, they specifically said at the Daubert hearing, we're not moving to exclude all of his opinions, just the blood alcohol content portion. And their argument about his opinion on that narrow issue, the blood alcohol content, assumes that the expert cannot rely on the plaintiff's testimony. I mean, their criticism is, how can you rely on this guy that doesn't remember everything when you've got an alcohol serum test? Well, an expert can testify based on, especially as a hypothetical, as was done here, based on anything that's in evidence. The plaintiff's testimony was in evidence. The criticisms about, well, you didn't consider this other evidence, that's all subject for cross-examination. That's not a basis for exclusion. And as Judge Eisnagel pointed out, if there was any error here, any abuse of discretion in allowing this narrow opinion, it would absolutely be harmless because the jury, it rejected his opinion in the case. They found that Mr. Hughes was in fact impaired at the time of the accident. On the issue of failing to make sufficient Daubert findings, this is absolutely an issue that was not preserved. One of the main purposes of the preservation rule is to put the trial court on notice and give the trial judge an opportunity to correct the problem. You can't just put a purported legal error in your pocket and wait and see what the jury does and then spring it on the trial court. They never raised this issue before the jury verdict, even though they had numerous opportunities to do so. We noted that when the court was giving his Daubert rulings open court, he invited counsel to jump in with any questions, comments, whatever it may be. Nothing was said. Nothing was said during trial. Judge, you've got to make specific findings. What you've done is insufficient. And as this court well knows, an appellant has to raise the specific reason for reversal with the trial court before. You can't just wait until after a jury verdict to raise those issues. So that issue was not preserved. And we do believe, even if it had been preserved, the record here supports the trial court's ruling. The judge absolutely considered the motions and arguments. You have to think about it in context, held several hearings, and did enter a written order denying a challenge to Dr. Goldberger that was brought by the plaintiffs. And if you look at that written order denying the challenge to Dr. Goldberger, he goes through Daubert, he goes through the factors, and he explains exactly why. And then at the beginning of the oral rulings on the Daubert, he says, hey, that was a prelude to what I'm going to tell you today. So in context, the judge is saying, these same reasons that I put into this written order apply for several of these experts, and that's the reasons that I'm providing to counsel as for my rulings. Counsel mentioned the cumulative error issues. One last point on the issue of the findings. It was not preserved, and there was nowhere in the initial brief where they argued fundamental error. Those words do not show up in the initial brief, so they've waived any argument to suggest that anything the trial court did below was fundamental error. That also applies with the arguments regarding Mr. Hughes' testimony and counsel's comments. The vast majority of those issues, there was no objection at all. And they even admitted in their reply brief, well, we didn't object to most of those. And there was never once a motion for a mistrial in this case. There was never once a request for a curative instruction. And that means that those issues relating to comments and counsel's comments and Mr. Hughes' testimony were clearly not preserved. Again, no mention of fundamental error in the appellant's brief. That issue is waived, and even if they had raised it, this does not constitute error, much less, let alone fundamental error. The last issue they raised dealt with the allocation of negligence, saying the jury couldn't have found the way it did based on the evidence, but they completely ignore all of the evidence that was presented at trial about the driver, Mr. Hestikin, driving the semi-truck with impaired vision, detailed evidence about all of his medical records. He did not tell his employer that he was having trouble driving at night. All of that information supports the jury's verdict in this case that Mr. Hestikin was negligent in the case. If the court has any questions regarding any of the issues I've addressed, I'm happy to address them. Otherwise, I'll rely on my brief.
Okay, hearing no questions. Mr. Curry, thank you very much. Mr. Corn, 4 minutes, 32 seconds.
Thank you, Your Honor. The fact that the word fundamental may not have been uttered does not mean that we didn't analyze in detail, including in the reply brief, all the standards under Murphy, under this court's opinion in City of Orlando versus Pinheiro, and those other things. We would rely on the case authority of R.J. Reynolds versus Callaway and this court's decision in Harrison, which talks about the ability of the court to consider both preserved and unpreserved issues that arose at trial to determine whether on a cumulative basis a fair trial occurred. This was a situation, Your Honors, where the plaintiffs got virtually every ruling pre-trial that they sought on the motions in limine. And we're not objecting to the motions in limine, but what they did was they used them both as a shield against the defense, but as a sword against them as well. Counsel mentioned that in their view, Paradiso and Murdoch used the same methodology. Respectfully, we disagree. They both looked at photographs because the rental vehicle that the plaintiff was driving had been wrecked and unavailable. But what they did with those photos is markedly different. What did Murdoch say he did? He eyeballed them. He didn't measure them like Paradiso did. He didn't go and look at the gouges in the road like Paradiso did. He omitted numerous steps. He basically said, you know, folks, I've been doing this for 40 years. I've been accepted as an expert many times in many places. My eyeball tells me that this speed was correct. Yet he mathematically erred when he testified during his deposition about the amount of time that it would have taken Mr. Hughes to get from the crest of the hill where his lights were first able to be seen to the impact point. That's not a some kind of a harmless error. That goes right to the foundation. And that's why the court erred in allowing this fellow to testify as to speed, because he failed to meet his gatekeeper capacity. You know, it's
Mr. Corn, just follow up on something Judge Eisnagel asked you earlier. Your expert testified to excessive speed, right?
Yes, but at a different, yes, he said that at the point of impact, Mr. Hughes was going approximately 80 miles an hour. He opined that he was going up to 97 miles an hour on that earlier stretch of the highway before the impact occurred. Whereas,
and the jury ended up agreeing with your expert and not the plaintiff's expert.
Well, we can't say that for sure, Your Honor, because the only interrogatory question that the jurors were asked about negligence dealt with the intoxication defense. The jurors found that both Hesketon and Hughes were liable. That's what those are the boxes that were checked on the verdict form. The special interrogatory form went to the alcohol impairment defense, which I've already referred to. So I'm not sure that we can say with any definitiveness that the jury accepted Mr. Paradiso's opinion over Mr. Murdoch's. Again, there was such a wide variety between the two opinions that one would have thought the court, in evaluating the admissibility, would have wanted to have explained why Mr. Murdoch's eyeballing was sufficient, why his methods were accepted, whether his eyeballing methodology had been subject to peer review or acceptance in the industry. This was an ipsy-dixit opinion, plain and simple. And it doesn't go to the weight that should have been applied, Your Honor, to the testimony that Murdoch gave. This is why the gatekeeper exists. This is why we adopted the Daubert standard in the first place, is to avoid this kind of pure opinion testimony to be presented to the jury. And so for these reasons, I would submit that this case ought to be reversed for a new trial. I would just mention one last thing. When you look at Rose's testimony, Ms. Curry is correct. The only objection was as to the BAC, but Rose himself went all over the place on that. He said first it was 0 at his deposition, then conceded up to 0.08. I see I'm into my stoppage time, so I will stop it as well. And I thank the court for your attention.
All right. Thank you, sir. Thank you, Mr. Curry. The court will stand in recess.
Thank you, sir.
Thank you.